Good morning, ladies and gentlemen. This is the September 28th, 2016 briefing session for the Utah Board of Oil, Gas, and Mining. Mr. Baza, if you would begin.
Good morning, Chairman Gill and members of the board. Again, John Baza, Director for the Division of Oil, Gas, and Mining. And we're going to provide you with a briefing this morning. I would start our session by explaining to you that I had invited some people from out of town, from Oklahoma City actually, executives from the Groundwater Protection Council and the Interstate Oil and Gas Compact Commission to observe these proceedings today on our live stream. I have two reasons for wanting to do that. One was to prove to everyone that we are really trying to extend our reach with the electronic capabilities of these hearings. And I know that we've had remote hearings before where we've had witnesses from other companies testifying, and I think that it's starting to prove up that electronically we can probably be in all corners of the globe with the information that we're providing to people about Utah and the actions of this board. Also, the second reason for me wanting to do this with these folks in Oklahoma City was that next month I'm hoping that we'll have the technology available so that they will be able to brief you remotely from Oklahoma City on the actions of those two organizations, the GWPC and the IOGCC. I think you'll enjoy hearing from them and hearing about the important issues that are being dealt with on a national stage regarding oil and gas development and groundwater protection throughout the United States. So be anticipating that we'll have them hopefully briefing you from Oklahoma City next month. The first item on our briefing agenda this morning is to have a discussion of recent actions of OSM and the interactions they've had with the Division of Oil, Gas, and Mining. They are many and frequent, and Dana Dean, our Associate Director for Mining, is going to come up and provide you with that briefing on what's been going on between the division and OSM. Just as a kind of to set the stage for this, OSM, the Office of Surface Mining, is an agency within the Department of Interior. They are responsible for administering SMCRA, the Surface Mining Control and Reclamation Act. And as part of that, they have a primacy delegation to various states to conduct those coal regulatory activities in each of the states. So our coal regulatory program and our abandoned mines regulatory program are part of that primacy delegation from SMCRA. So OSM is essentially an oversight agency for us. We have to do things in accord with federal standards, federal rules, federal guidelines, and as part of our cooperative agreement with OSM under the primacy delegation. So with that in mind, I'll go ahead and let Dana explain to you what's been happening recently.
Yes, good morning, Mr. Chair and Board. Again, I'm Dana Dean, and a few things that I'll be talking about today. I'll just give some definitions up front. A 10-day notice is a notice from the Office of Surface Mining that we need to correct a problem or explain why it is not a problem, or they will initiate a 733 process. The 733 process is where the Office of Surface Mining alleges that we are not doing our job properly in our entire program or part of our program. So for example, they could say, you're not doing bonding properly, we're going to take over that part of your program. That has happened in at least one other state. So those are the threats kind of that are out there with these types of actions. In the past 15 years since I've been working for the division, we've had a really good working relationship with Denver. We have what's called, we call it now the evaluation team, and it has worked as a team. We've worked well together. Issues usually were resolved through that evaluation team. If there were anything things that people thought we were maybe needed to improve on. You know, we were happy to improve those if pointed out, and they were done in a friendly manner. Beginning earlier this year, things sort of shifted a little bit, and I think we were lucky in Utah that this hadn't happened 10 years ago, because it was exactly what we were hearing in other states. A bunch of 10-day notices and 733 letter threats were happening in other states. On January 12th of this year, in response to a letter that Wild Earth Guardians had written to OSM in December of 2015, we received 3 10-day notices, one each for the Dugout, Skyline, and Sufco mines, alleging that they were not properly bonded. The information that came from Wild Earth Guardians was poorly researched. It claimed that we were not periodically updating our bonds because they looked at what we do at permit renewal. We update our bonds at the mid-term of the permit instead of permit renewal, so that we're not up against a deadline and we can take the proper time to fix anything that we think is wrong. So we have a very intensive midterm review, and that includes an update of the bond. That was one issue that was just extremely off base. The thing is, when the Office of Surface Mining, under their current policy, if they get any citizen's complaint, they cannot investigate that themselves. They immediately must write a 10-day notice to the state and allege that whatever the citizen complaint says is wrong and the state is in the wrong. This particular citizen's complaint also requested a 733 review of the bonding portion of the Division of Oil, Gas, and Mining's coal program. So we spent a lot of time responding to this. We responded on time. Like I said, we have 10 days to turn this around. Steve Alder and Melissa Reynolds did the bulk of the work on that, working with technical people from the coal program, but they did a lot of the work in writing up the response. We have not heard back. They were supposed to respond to us by the first week of February on this 10-day notice. There is a provision in their rules, though, that if it's technical in nature, they can take longer. Well, they're taking a lot longer. I've heard from Alan Beams a couple of times. Back in March, he called me and said he thought they were almost done and that the review would just say that we were correct. About a month and a half ago, he said, oh, by the end of the month, which I believe was July, he expected it to come out favorably, except for some small issues that they would change into an oversight team evaluation thing. And if that were something like we have a 10% factor that we kind of just made up but thought would be good sense to, if someone does something new and it doesn't increase their bond by more than 10%, we usually don't require them to go out and do all the work to get new bonding until they get up to that 10%. If OSM were to come say we couldn't do that anymore, I think we would say, okay, that makes sense, that's fine. There is another issue, though, that we know they may disagree with us on, and that is where mine has torn down a building or some other structure. They think that needs to be bonded until phase 1 bond release, and we disagree. And a great example that Darren Haddock brought up was, say you have your whole conveyor line, you're going to upgrade it to a bigger conveyor line. So you tear down the old one, build a new one. OSM thinks that you should have both of those in your bond forever until you've done the earthwork and that entire area is reseeded and ready for bond release. We think if you tear down a structure, you should be given credit for tearing down that structure. So we would appeal that. So we're just waiting to see on that. Again, no word on exactly when it will come out. And depending on what it says, we'll either just work with them to make changes or appeal, depending on whether we think they're right or not. The 733 letter portion of that, we did finally get a reply on August 16th from David Berry, the regional director, and it said that the Office of the Director, Joe Pizarchik, had reviewed this and they did not feel that a 733 review was warranted. So we weren't scared of that. We knew that would be the outcome. We think that we probably do the best bonding out there. We have very good technical people. We review these every 2.5 or every 5 years. We recently had just updated the 3 mines that they had pinpointed anyway, so we were pretty certain that those were correct numbers, but this issue of tearing something down was a question. So we're waiting on that. We don't know what the answer on that one is. I forgot to write down the date here, but I believe it was April or May. The Bear Canyon mine. Last year there was an oversight inspection up there, and there were some issues. Their conveyor belt, the pans were not holding coal fines when water was involved. So if there was a rainstorm or they did have a pipe burst, a bunch of coal fines went off from the conveyor belt and fell into an area of their mine that is supposed to be a stream buffer zone because there's a spring there. At the time last year when the OSM inspector was out here, the division wrote several violations and required them to fix that. When the inspector came back this year, he thought it looked exactly the same as last year, and he wrote a 10-day notice saying that we had not fixed the situation. We went up as a group, inspected, and frankly we agreed with the OSM inspector. There was a lot of coal on the ground in a stream buffer zone, and it should have been a violation. And so we reinstated some of the older violations and we wrote a new violation. In the company's defense, they had done some cleanup and further spills occurred. So this last violation we wrote required them to fix the conveyor belt as well. Darren Haddock was just up there yesterday. He said that he felt like he could terminate this latest violation. The cleanup looked good enough to terminate the violation, and they had done a lot of work on the conveyor belt, but he did warn them that he thought that the conveyor belt still could have some issues, and that they would have to be very diligent in cleaning up any spills immediately and not letting them accumulate like they were before. It was a lot of coal on the ground when we went up there. So that was resolved by us writing an NOV. The third was probably the most unfortunate and probably what prompted John to want me to pass this on to you as the board. We had an evaluation team topic where we were going to go out and look at vegetative reference areas at different mines. So each year what our evaluation team does is we meet quarterly by phone with the folks from Denver. We have certain people on our team, they have people on their team, and each year we choose some topics so that they can come in and see, are we appropriately applying our program? And then at the end of the year we work together to write up an evaluation report, and it says, yep, they're doing a great job, or yeah, they're doing a great job, but we could do better if we did such and such. And so it's supposed to be a team approach. Well, this team met at the Skyline Mine, and some people were already riled up over some things that apparently they thought were rules and were not. And so we got 2 TDNs out of this evaluation visit. One was for the Skyline Mine and one was for the Westridge Mine. This was in June of this year. And they were very off the mark. They were talking about monitoring requirements, staking requirements, and they were misunderstanding the state rules and also the state guidelines and which parts of those guidelines were supposed to be rule and which weren't. The 2 TDNs were poorly written. One referred to a rule that had nothing to do with what they were talking about. And in our response, we pointedly talked about the lack of cooperation, that they were not following the charter of this evaluation team. This should not have been a 10-day notice situation. And, you know, we were not kind in the response on this one to the specific inspector who had caused the problem. We got a response on July 1st that the TDNs were vacated, that they were unwarranted. We were correct. And the evaluation topic review also said that we were correct. No violations were existing. The mines were doing exactly what they needed to be doing. They were following the rules properly, and OSM was misunderstanding. So that got resolved, and I believe that there was a little bit of shuffling in OSM since then. I think they're trying to be a little more prudent in 10-day notices. I think there's more review of whether or not they should write one, or at least to me they've seemed more cooperative since we kind of slammed them in our last review, saying we don't mind being regulated and we want to do the right thing, but when you're just wasting our time, because it takes 10 days of Melissa and John or Steve Alder's time when they're busy with other issues to set aside and write a very clear and concise response to these, to get on the record that we're doing things the proper way. And I think that they realize that they don't want to necessarily be wasting our time. The issue I am concerned about, and maybe I shouldn't be saying it here on YouTube though, is they still have that policy of any citizen's complaint is an automatic 10-day notice. And that has been used as a tool against many other states to just, including Colorado, where the current regional director came from, to just slow things down. And I hope that that doesn't become a bigger issue in the state of Utah, but it could until they change that policy. But for now, I think that we're doing things the right way, and we're not afraid of these 10-day notices. We don't like wasting the time to say, hey, we were right in the first place. But I feel that we have prevailed in most cases. We're still waiting on the bonding one. I think that anything they find will be small changes that we'll have to make, and we're willing to do that. But I think for the most part, we have shown that we were diligently following the state rules properly, and OSM has agreed with us.
If I can jump in here for a minute, it was interesting to us, Dana and I, as we would attend the Interstate Mining Compact Commission meetings with other states, that about 4, 5, 6 years ago, there were some criticisms of OSM that they were not being strong-handed enough with the state oversight programs. And we would hear from other states that, we've got all these 10-day notices, we've got all of these enforcement actions that OSM is taking to try to force the state's hand into doing more. And we kind of, Dana and I were kind of the standout saying, well, we have a pretty good relationship with the Western region. We're not seeing the same things you guys are seeing. But we've always been kind of worried that it was headed our way. And I think what the past year has shown is it's landed in our lap now, and we're just trying to deal with it. But there are situations that we've heard in other states where they're getting 10-day notices every month of the year, that there's not a single month that they're idle with trying to respond to a 10-day notice. And as Dana said, that's really ineffective for a regulatory program, because it takes you away from the things you should be doing to be productive, to make sure that you're fostering responsible development, and it forces you to basically justify your existence as a regulatory program. So it's a difficult situation that we're in, but I needed to explain that to you because as far as I'm concerned, out of all the programs in the division, the coal program operates by some of the most stringent rules. I mean, there's a plethora of rules in the coal program that people have to adhere to, and I think that our staff has done a wonderful job in trying to apply those rules in a common sense manner.
I agree.
So we're happy to answer any questions you might have about that.
Board members, any questions or comments?
I have a question. Dana, you said that this is a policy with the federal government to respond.
Yes.
Yes. It seems to me that people that affect that policy probably don't like it either. They can clearly see when a request is probably not well-founded, do they have any recourse at all, or
No.
they absolutely have to respond?
No. So, and actually, I would say that the people in Denver are different from the people back in Washington, D.C. The people in Denver probably don't like just writing a 10-day notice based on whatever comes in. We had several meetings before they implemented this new policy with the director of OSM and several people from that office, and they were very clear that this would be the best way to go. It would save them time, and we saw the problem before they even began, and they were very gung-ho about implementing it because, as John said, they felt like they weren't writing enough violations. That's truly what they came into the meeting and said. We've done a review and we haven't written enough violations, so we're changing our policy so that if any citizen's complaint comes in, we don't look at it at all. We pawn it off onto you in a 10-day notice, and then if there's further action, we'll take it. If not, then we'll just... And so, yes, the people on the ground, the inspectors in Denver, they probably would rather be able to say, oh, well, I can see from this that it's not really legitimate. This really shouldn't waste anyone's time, but they can't because of what Washington has implemented and required of all states.
Other questions on this side?
I appreciate the candor with which you are describing the problem, and I agree that OSM's director has certainly made it interesting with this policy. And as the recipient of our company of some of these 10-day notices, I agree that they are frivolous at best. They're, I believe, the result of some folks manipulating the system to try and bring about changes that they would like that are not necessarily in agreement with what the regulations allow. But I guess the question I have is, do you see with Dave Barry as the new Western Regional Director for OSM, do you sense that he's starting to take more control of the office over there?
Yes, I think that, I mean, I haven't seen or spoken with Dave, but from the feeling I get that after some of the things that happened this summer, he's taking a little more interest in what's going on. And frankly, while Dave Barry was the coal program manager in Colorado, they got many of these frivolous 10-day notices. They actually sued OSM for some of them because there was one citizen who, you know, I think OSM finally did concede, okay, when this person calls, I guess we won't turn this into a 10-day notice because they've all been found to be frivolous, you know. And so I think he understands the situation. I don't think that he was aware of exactly what was going on at the staff level on some of these. And I think that he has, I think things are different now than they were by the time we got that reply from Alan Beams on July 1st saying that, oh, these two 10-day notices on the vegetation reference were, you're right, we were wrong on those. I think since that, I've seen sort of a shift in at least how Alan, how the evaluation team is working.
There is a Western States meeting that's going to happen with OSM in Denver at the end of November. And even though we've tried to be very frugal with our travel expenses, Dana and I both felt it was important for both of us to be at that meeting so that we could talk directly with Dave and the OSM staff about these issues, because we're not the only ones in the Western region that are seeing this kind of behavior. And we need to get an understanding. Is this going to continue? You know, will the beatings continue until morale improves? Or are we going to have to do something more proactive in terms of pushing back?
Right. Also at the IMCC meeting that's next month here in Park City, We will be putting together a transition team report for whoever the next president is. We don't know, who it will be, but one of the big issues that will be in that report is this change that they made several years ago, and that it is not working. Just automatically writing 10-day notices with no thought whatsoever isn't working, and we will be pushing once again. We've been pushing for years for them to change that back, but that this will be a chance, at least with a new president, hopefully a new director of OSM. I don't know what will really, I can't predict the future, but we're hoping there's a change at OSM and that we can get someone that will listen to us. But it could be, like it's been the last few years, just talking to a brick wall. They think that's the best policy and they want to stick with it. But IMCC and the Western States Group are both very cognizant of this issue and working together to try and improve the way things work.
As a member of the regulated community, let me just say that I appreciate the efforts that DOGM OGM has made in pushing back on these 10-day notices that are, in my opinion, somewhat ridiculous and should never have been issued. And I appreciate the hard work that you and your staff are doing to implement the state program under the federal guidelines, and the good work that you folks do.
Thank you.
Thank you.
Thank you. Thanks, Dana. Appreciate that. The next item on our agenda is to just present to you, the Board Secretary, Julianne Carter, has provided a listing of proposed hearing dates for calendar year 2017. No action is needed on this at this point. It's basically for you to look at, compare it to your calendars, and if you see any conflicts, this is something that we'd actually ask you to consent to at next month's hearing. I would add a couple of comments to that. We had pulled back on having field hearings just because of the budget process and the things we were facing as a division and trying to curtail our expenses. But I really do feel that there's value in having a field hearing of the board, whether it's in the Uinta Basin, in the Price area, or elsewhere, that it's an opportunity for the people in those areas to see the activity of the board, to hear about issues that are in front of the board. And so I'm going to recommend to you that we do have at least one field hearing next year. I don't know where yet. We'll still try to have at least 2 field trips of the board, but I think it would be wise if we basically try to insert a field hearing again into the board schedule. I'd be happy to address any interests you might have and places you want to go or areas you want to visit, even the time of year that you might want to do that. But keep that in mind as you look at the hearing schedule of where you might want to go and where you might want to have a field hearing.
Thank you.
Okay. Under other items, I'll mention something that can probably be looked at in terms of reviewing the calendar. But last year, as you recall, for the board's holiday social, we had a reception and open house the day of the December board hearing, right here in the building at the back of the auditorium, and I thought that was pretty successful. At the time, we had guests from the Idaho Lands Commission who came and visited with us. It offered an opportunity for attorneys who practice in front of the board to come in after work and just mix and mingle and just enjoy a very casual social setting with the board. It was conducted at very low cost because we were using our own building to do it in. So I'm suggesting to you that we do something along those same lines this year. And I guess the decision to make is, do you want to do that type of function? And then which night? Because we could either do it the night before the board's December hearing, or we could do it the day of. It's just that right now we don't have a good handle on what specific agenda items might be coming up and how long a day that might be. So if you would ponder that and maybe give me some feedback, you don't have to do it today, but think about if you want to go ahead and do that type of open house reception here in the building, and then which night you might want to do it. And then I'm going to go through the calendar a bit. You can see us, I think you have 3 months in front of you. We've got our hearing today. Starting next week, there is an IOGCC annual conference which takes place in Little Rock, Arkansas. Again, we've limited travel to that, but it's been a whole year since the division participated in IOGCC meetings, so I will be attending that meeting in Arkansas next week. We do have a collaborative meeting for the oil and gas program out in Duchesne on the 13th of October, and there's an agenda for that. Hopefully you've read an email on that recently. We have our board hearing scheduled for the 26th of October, which will be the last one we have before the December board hearing. I would say that the day before, and Chairman Gill knows we had a meeting at the end of August to talk about funding issues in the oil and gas program. So on the 25th of October, we're going to bring that group back together and continue that discussion to see if we can brainstorm some longer term diversified funding things that we might be able to do. We really haven't proposed anything specific. I was in front of the Natural Resources Appropriations Subcommittee last Friday, and I tried to explain to them that we're not asking for any dollars this year. We're not proposing any specific help from the legislature, because we did get some last year, which we certainly appreciate. But we just want to make them aware that relying on a production tax may not be the sole source of funding that we want to look at into the future, especially if this roller coaster of pricing, if it should rise and then dip again, we want to be ready for those types of things as they happen into the future. So we'll continue that discussion on the 25th of October, and you're certainly welcome to participate, but we'll also do the same type of live streaming of that so that you can, if you're not here, you can certainly listen to it and even interactively ask questions during the meeting. And then, as you know, we combine our November and December hearings because of the holidays into one meeting on the first week of December, which this year will be on December 7th. So, Mr. Chairman and members of the board, that's as much as we have for the briefing at this time. You could certainly take the opportunity to hear from members of the public if you'd like, and then we'll commence into our formal agenda matters by 10 o'clock.
Okay. The board members, before we go to the public, any questions in general that you might have for the division? Seeing none, then this is the time for public comment. If there's a member of the public that has an issue that's within our jurisdiction that you'd like to address at this time, please come forward. Seeing none, then we will have a break and be back at 10 a.m. Thank you very much.
Thank you.